may be shocked to learn that nowhere in the original text of the US Constitution does it say that citizens have a right to vote.
So many people find it surprising, but the original Constitution as drafted did not include a right to vote. And, that is one of the flaws in the document. There's no question about it. The, senators were originally selected by state legislatures. The president was chosen by through the Electoral College, which also gave the state legislatures a lot of powers. It was really only the House of Representatives that was anticipated that people would have direct elections for. And even then, who was allowed to vote was restricted to white men, and in many states to white men who held property.
So where does the right to vote come from? I'm Sophie Feldman from Democracy Docket, and today I'm going to be breaking down the US Constitution's voting rights protections. It wasn't until after the Civil War and the abolition of slavery that there was this massive push to expand voting rights to more Americans. While we may and do think of voting as an integral part of our democracy, there weren't explicit constitutional protections for it until later amendments.
So what we saw thereafter was a broad expansion of the right to vote in other amendments to the Constitution. After the Civil War, the 14th and 15th Amendments were added to give Black men the right to vote. Following that, in the 17th Amendment, the direct election of U.S. senators was put in the Constitution, so people for the first time got the right to vote for U.S. Senate. It wasn't until the 19th Amendment that women got the right to vote. The 24th did away with poll taxes and really started to kick off the modern era of voting protections. And then, of course, the 26th Amendment lowered the age for voting to 18. It guaranteed 18-year-olds the right to vote on the same terms as older votes. So this has been a project over time to expand voting rights in the Constitution.
These amendments were critical for enshrining the fundamental right to vote for millions more Americans in our Constitution. But that doesn't mean states haven't tried to pass laws restricting or undermining voting rights, specifically against minority groups. Voters have been able to use these amendments as legal tools to fight against discriminatory voting practices. The Equal Protection Clause of the 14th Amendment has specifically been used to fight against racial gerrymandered electoral districts, which is when race is illegally used as the predominant factor in map drawing. The 14th Amendment has been utilized in numerous lawsuits across the country and has been used by the Supreme Court as recently as 2017 to strike down North Carolina's congressional map as a racial gerrymander. But this key protection has become a growing target of Republicans. Just this year, the Supreme Court ruled in favor of Republicans and severely narrowed the scope of the 14th Amendment in racial gerrymandering cases, overturning decades of precedent. This tool that has been vital for protecting voters, specifically Black voters, for decades, has been stripped of its teeth by the far-right majority on the Supreme Court at the request of Republicans.
But look, these provisions of voting rights have been under attack increasingly by Republicans. We have seen Republicans, believe it or not, run on platforms in some races to repeal the 17th Amendment, literally to undo the right to elect U.S. senators directly. And we saw after the 2020 election, Republican legislatures tried to claw back the ability to appoint electors in the Electoral College. A wildly undemocratic effort and one that violates the Constitution and federal law. But it is not time to rest on our laurels. The fact is that voting rights are under attack like we have never seen before. So even though the Constitution has strengthened the right to vote through amendments, and we have seen laws enacted by Congress to strengthen the right to vote, Republicans are in court around this country to try to cut back on the right to vote, on the ability to have people's ballots counted, have them counted accurately and certified. And that is the fight of our generation. It is not the one we would have picked, but it is the one we have.
Importantly, these amendments give Congress and the federal government the power to enforce their protections through legislation. And it's in these federal laws that we can find the greatest tools to protect voting rights. The Enforcement Act of 1870, also known as the Civil Rights Act of 1870, or the first Ku Klux Klan Act, empowered President Ulysses S. Grant to enforce the 15th Amendment by making it illegal to disenfranchise Black voters and allowing the president to use federal marshals to bring charges against offenders. Similarly, the landmark Voting Rights Act of 1965 relies on Congress's power to enforce the 14th and 15th Amendments and gave the federal government and individuals more legal tools to challenge racially discriminatory voting practices. As a result, the amendments not only created strong protections for the right to vote, but gave Congress a more active role in enforcing these protections. These statutes, too, have been attacked by Republicans. Over the last few years, we've seen a storm of GOP-backed lawsuits trying to curtail these critical voting rights laws. In a landmark 2013 Supreme Court decision, the court gutted the Voting Rights Act's pre-clearance requirements, which mandated that places with a history of racial discrimination get approval from the federal government before making changes to voting laws or districts. Now, Republicans have focused on Section 2, the most utilized portion of the VRA, which prohibits racial discrimination. From trying to get it struck down completely to arguing that individuals and civil rights groups don't even have the right to sue under it, it's clear that Republicans' attacks on this law are far from over. With a hyper-polarized Congress and a Supreme Court unfavorable to voting rights, it's been mostly up to the states to take action to protect voting. That's where there's good news. Even though the U.S. Constitution doesn't contain an explicit right to vote, almost all state constitutions do. And in 30 states, their state constitutions contain additional voting protections. 12 states have some form of constitutional requirement that elections be free, and 18 states go even further, requiring that elections be free and equal or open. After the Supreme Court shut the door for federal courts to review claims of partisan gerrymandering in 2019, a claim that districts unfairly benefit a certain political party or candidate, more states are interpreting their state constitutions to protect against this type of gerrymandering. Maps have been struck down in numerous states such as Ohio, Alaska, Maryland, New York, North Carolina, Pennsylvania, New Mexico, Utah, and Wisconsin for being partisan gerrymanders, violating their respective state constitutions. And through the ballot initiative process, voters have been able to pass their own pro-voting measures such as in Michigan, Connecticut, and Ohio. But the easiest and most effective way to ensure standard voting protections across the states is by passing new federal voting rights legislation. Multiple bills, such as the John Lewis Voting Rights Advancement Act and the Freedom to Vote Act, have been pushed by Democrats time and time again, but have been ultimately blocked by Republicans.
And we need to elect Kamala Harris and Democrats to the U.S. House and Senate, and then we need them to enact federal legislation to effectuate the rights guaranteed by the 14th, 15th, 17th, 19th, 24th, and 26th Amendment. Only when Congress does that can we all breathe a deep sigh of relief that democracy will be protected for the next generation.
Thanks for watching Democracy Docket. If you want to stay up to date on all things voting and elections, make sure you're subscribed to our newsletters. You can click the link right here on the screen or in the description of this video. I'm Sophie, and I'll see you next time.